Fundamental series. I'm Cheryl Piasecki, and I'm very pleased to be joined today by two of my colleagues from the ethics community. Dan Fort is an ethics official with the Environmental Protection Agency, and Karen Santoro is the DAEO at the National Science Foundation, and I want to welcome you both to the show today.
Thank you.
For those of you who may have attended the OGE Summit in March, I just wanted to alert you that this is, in many respects, a similar presentation, if not an identical presentation from what we delivered at the summit. This was not a session that had been streamed, so that's why we decided to have it be one of our fundamental series broadcasts. And before we get started on today's session, where we're going to be talking about managing SGE service, I do have a few brief announcements. Next week for the Advanced Practitioner Series, we're also going to be we have also invited some folks from outside of OGE to come in for a panel presentation. The discussion is going to be on the interplay between FOIA, the Ethics in Government Act, and the Privacy Act with respect to ethics documents. I think that that's something that's of great interest to the community, and so we're really pleased to be able to offer that to you next week. The first week in May is what tentatively we have scheduled to deliver our 3-day 278E massive open online course. What we will be doing is introducing sort of introductory level review of the 278E. As I said, it will be a 3-day massive open online course, so there will be exercises and application exercises that we would invite you to engage in. So be looking for announcements about that probably in the first week in May. And with that, Patrick, if you would be willing to bring up our slide deck, we'll go ahead and get started with today's discussion about managing SGEs. Okay, well, I think, Karen and Dan, I think SGEs are a concept that I think a lot of people find quite confusing for a variety of reasons. I think in large measure because the folks aren't even sure, I don't think, where the definition of this comes from, like what this concept is related to. And as I've pulled up here on this slide, curiously enough, where you find the definition of an SGE is in Title 18 of the United States Code, and that's in the Criminal Conflict of Interest Statutes in 202, where all the definitions for the Criminal Conflict of Interest Statutes reside. And I think, unfortunately, a lot of folks think that this is somehow a personnel law concept. And so I think when it comes to sort of managing SGEs and deciding who's responsible for identifying them, who's responsible for tracking them, how we even know who is an SGE, I think the very fact that it got its genesis is in the conflict of interest laws sort of makes life a little complicated for everyone. Would you agree with that?
I would agree with that. And it's just fascinating that the reason, and it must be, oh my God, it must be over half a century ago, that the whole idea of SGEs came into being was that the government needed the temporary services of people to serve as government employees for their particular expertise. It wasn't that you were going to get a federal job like those of us here who are all regular government employees, and probably most of the people listening are regular government employees. The idea was to only have temporary service to assist the government for a short period of time.
Right. And if you look at the definition, that's pretty much what the definition is an indication of. It says the term special government employee is an officer or an employee who is retained, designated, appointed, or employed to perform, and it's with or without compensation, not to exceed 130 days, temporary duties, either on a full-time or an intermittent basis. So the very nature of special government employees is the intent is that they will be temporary employees. There's not an intention that they would be full-time federal government employees. So understanding that that is the definition, and that's where the definition resides, I think one of the first points that we have to be very cognizant of is that special government employees are first and foremost employees. For someone to have an SGE status, they have to be an employee. And so what OGE has said in its advisories is that you look for indicia of employment where that definition resides, which is in 5 U.S.C. 2105. And in that statute, they basically lay out 3 rather vague, I would say, criteria for what constitutes someone having employee status with the government. And that's that they've been appointed to the civil service, that they have an appointment, they're performing a federal function, and they're being supervised by a federal official. Now, I know this comes up and people might be saying, well, why would we ever have to question whether or not somebody was an SGE or an employee? And we're going to talk about this in a little bit more detail later, but there are folks who come to provide service to the government who are considered representatives. And when you're making designations about whether or not that individual service makes them subject to any ethics rules, you have to first determine whether or not they are actually a representative or an employee. And these are three of the criteria that 5 USC lays out as to what makes someone employee. And Dan, you and I were talking a little bit earlier about how EPA, because you said you do have some representatives in some of your committees, correct?
Yes, we do.
Okay, so you want to share with folks, and we're going to talk about this in a little bit more detail later, but I thought it was really interesting that you said that you had like 4 things that you all look to when you're trying to decide whether someone is an employee or a representative.
Yeah, thank you. What we did is put together an EPA document, Ethics Advisory, where we laid out the criteria by which you would determine whether somebody would be a representative or a special government employee. And what we did is we took a lot of OG's legal advisories, informal advisories, and sort of smacked them all together so we could have one convenient document to look at. So there's really 4 things that we look at. One is we look at the anticipated role of the advisory committee member. What are they going to be doing? Are they there for their expertise, or are they there because they're representing a group or a viewpoint? We also ask ourselves, is the member going to receive compensation from the agency? Was the member appointed by recommendation by outside parties? And lastly, does the enabling legislation for the committee, if it's statutory committee, or their committee charter, sort of help you determine what kind of advisory committee members you're going to have, either representatives or special government employees?
Okay. And we're going to come back to that, and I'm going to ask you to elaborate on that a little bit more later when we actually start talking more specifically and discreetly about representatives, because you've touched on some of the things that I think are really material to that determination. But for right now, we're going to sort of like continue on with when you have made a determination and you know that the people that you have appointed are actually employees such that they are legitimately special government employees. I think it's important to understand what makes these people special. Like, why is this category of employees somehow, how are they separated out from regular rank and file employees? Because you can be temporary, you can be part-time, you can be full-time. And so where's that line drawn, and what makes somebody suddenly special? The first thing is that the duties are temporary, and the definition in the statute itself says exactly what temporary means. And it means that they serve 130 days or less in a 365-day consecutive period. So you would calculate that, like, from the date that they would be appointed. If you do a 365-degree look ahead of that appointment date, you make an estimation about whether or not you anticipate that they're going to serve for 130 days or less. If you fully anticipate that their service will meet that day counting criterion, then you can consider them SGEs and designate them as special government employees. And then that SGE status remains with them throughout that entire 1-year appointment period. Now, I don't know, have you all had experiences where your SGEs have exceeded the 130-day period?
We've had a couple, and it's our personnel office that notifies us of the days. And at that point, we get back to the SGE and say, you're no longer special. Here are the additional ethics rules that apply to you.
Okay. And I'm curious that when you have people who extend for an additional year, like their appointment is going to extend beyond the additional year, do you then reevaluate their status for however long that their appointment is going to be?
We basically look at what their duties are going to be. If we need them for advice, then we would mainly consider them special government employees.
Okay. So really it comes down to the SGE status is basically a day counting function. You have to look at the number of days that you anticipate someone is going to provide services, and if they're going to fall within that ambit of that day counting. they're special government employees, not just part-time employees. Because you can have somebody who's working part-time, but if they're going to work more than 130 days and you anticipate they're going to work more than 130 days, they don't get the special government employee moniker. The other thing is you don't have to pay special government employees. They can serve with or without compensation. And as Dan and Karen are both going to talk about here in a little bit, the ethics rules are going to apply, somewhat differently in some contexts. Some of the rules and laws apply the same, and some of the rules and laws apply differently. And we're going to sort of parse that out later on in today's presentation. One advisory, Dan mentioned that EPA has sort of tried to come up with a comprehensive document that pulls together a lot of the advisories and that OGE has issued dealing with SGEs. But one of the most comprehensive that OGE issued, and I think is still relevant and still it's still applicable, is the OGE advisory from February 15th of 2000, and you can find that on OGE's website. This really has to be, if you deal with SGEs, this has to be in your arsenal. You have to have this advisory in your toolkit and have read it and looked at it, because it covers everything from day counting to what are the indicia of employee status to walking you through literally every standards of conduct and every conflict of interest statute and letting you know which ones apply to SGEs and specifically how they apply to SGEs. Yeah, Patrick, did you have a?
Yes, we do. We have a couple of questions coming in over the Hangout that I think are timely. And the first question is, this person thought that SGEs could remain SGEs if they work more than 130 days, as long as there was a good faith estimate made at the beginning. Could you speak to that?
I think an OGE's interpretation is that when you make a designation at the beginning of the appointment, then that lasts for the extension of the appointment. But if they exceed the 130 days, that what we advise in our guidance document is that should inform your next assessment about whether or not they retain SGE status for any subsequent appointments. I think that's what OGE's guidance document says.
Excellent, thank you.
Was there another question, or?
Yes, and there is another question, and this question is: can you recoup any money paid to them if they have worked over the 130 days? How does that work for compensation?
I'm going to ask Dan and Karen to address that question.
Outside of my field, however.
Yes, I do not know.
Okay. So you've stumped us. You stumped the panel.
Quick, call a personnel lawyer.
I know. I have no question. No, who would you consult on a situation like that? Like
Probably personnel folks.
Okay.
My guess is, once you pay them, you pay them. But not my field, however.
Right. Okay. All right. Back on the slide deck, Patrick, if you could. Okay. So we're going to divide, the SGE moniker into sort of two separate groups. We could quibble about whether or not this may or may not be the best way to divide up SGEs for purposes of understanding the different variations in which they come. But I think for purposes of our presentation today, this makes pretty good sense. We have what we call FOKA SGEs, who are special government employees who are serving as members on federal advisory committees that are subject to the Federal Advisory Committee Act. So it stands to reason that if that's one subgroup, there is actually another group, which are non-FOKA, which are SGEs who may be on committees, maybe serving on advisory committees that aren't subject to the Federal Advisory Committee Act. Or there's also this other group, which aren't necessarily committee members at all, but are people who are hired on a temporary basis to serve as experts or consultants to the agency. And it's by virtue of the fact that it's temporary duties for 130 days or less, which is what makes them a special government employee. Like I said, we've divided this into FOKA versus non-FOKA. And I'm going to ask, this is just the next slide is just a little thing that we got from the 2014 OGE annual questionnaire to give you kind of a breakdown of when we are talking about particularly advisory committee SGEs, the preponderance of SGEs that we have in the federal government who serve on advisory committees are serving on FOKA advisory committees. As you can see, the numbers sort of like spell that out for us. But what I'm going to ask my two colleagues here to talk about, because I am not a resident expert on FOKA, and these two folks really have a lot of experience, is to sort of briefly explain, what is FOKA, what is its purpose, who heads it up, who's responsible for it, where do you look for guidance, and Karen, Dan, either of you jump in and kind of take charge of this one.
I'll let you do this one.
So my understanding is that FOKA was enacted so that the work of the government could be transparent. So when we call in our outside experts, the public ought to know about that. They get notified of meetings. They have the opportunity to attend if it's open. They know who our experts are, and they know the basis on which we arrived at our decisions. Mm-hmm. It's actually GSA that enforces the FOKA law and the regulations. Mm-hmm. They have a committee management secretariat.
Okay. And do either of you have non-FOKA committees that you deal with?
We have one that concerns diving safety in the Antarctic.
Ooh, see, you have all the sexy advisory committees at the National Science Foundation.
But we do have non-FOKA SGEs who are outside of the committees.
The committees. So you have experts and consultants who are SGEs.
Right. We typically refer to them as intermittent experts.
Okay. Do you know, or can you address the issue of how do you know if your committee is a FOKA committee or not?
All of ours are, except the one I mentioned, and it's due to the charter.
Okay, so the charter would indicate whether or not it was intended to be a FOKA committee? Is that
yes.
Correct? Okay. Okay. So the issue with FOKA is we're looking for transparency, right? We're looking for transparency and accountability, that, to the extent that we're bringing in experts to advise the government, those processes are transparent and the public has an opportunity to see like what people are discussing and bringing to the table. Is that kind of generally
yes,
correct?
Okay. That's the reason FOKA was enacted in the first place, is to provide that transparency which was lacking prior to its enactment.
Okay.
And we do have another question coming in over the Hangout, and this also deals with how agencies designate and keep track of special government employees. And this question is probably for Dan and Karen. How do you keep track of who is an SGE? Do you just note that on the SF50, or are there other ways that you make that formal designation?
Well, in our case, which I'll get to in a moment, we actually have our very own form, confidential financial disclosure form, which we created and for which we got approval from OGE. And we make all of our special government employees fill it out as long as they are confidential financial disclosure filers. If we have an SG who meets the criteria for meeting the public financial disclosure, and I don't think we've had any of those for at least maybe a year, maybe 2 years, probably more. In that case, then of course they're obligated to fill out the OG 278E and be in integrity, of course. So if they are an SGE, they fill out an entirely different form than the OG 450, although it has many similarities to the 450. So by definition, we know who they are.
So like EPA, the National Science Foundation has its own alternative confidential filing disclosure form for our SGEs, but it only applies to our SGEs who are on advisory committees or our proposal review panels. The non-FOKA SGEs would typically either file a 278E or a 450.
Okay.
And it is the office that does the hiring who tells personnel, we want this individual to only serve this many days, and that's how the SGE is designated.
Okay. So effectively, it's the hiring official informs personnel, and then you get notified because they are filers. So it's through the filing process that your office gets notified that these folks are on board.
We are notified of every new hire.
Okay.
Because we do new employee orientation for everyone.
And Dan?
In our case, we have a very decentralized system at EPA. So it would go to the individual office that's hiring the SGEs.
Okay. So how does your office know if you're missing a financial disclosure form, or if so I think, because I think with the question that someone was asking is, how do you track that? Like, how do you know if your universe of SGEs, if you're aware of the universe of SGEs?
Well, we do a survey every year to find out how many, using the OG's annual survey, to find out how many SGEs we have, whether they file financial disclosure forms, how many they had, et cetera, et cetera. But in terms of looking at and reviewing these individual SGEs, that will end up being devolved down to our deputy ethics official, whose power flows by EPA order down to the level outside of the Office of General Counsel Ethics.
Okay. Karen?
For our FOKA SGEs, we rely on the designated federal official for that committee or panel to collect the forms and review them. And they can consult us if they have questions. For our non-FOKA SGEs, we have an electronic filing system that will automatically notify us when people are delinquent and send reminders.
Okay. Okay. Very good. Okay. So the FOKA rules contain some references, actual references to the role of ethics officials in the Federal Advisory Committee, sort of process. One of the things that we have quoted here is that the DAEO should be consulted prior to appointing members, and then this other, the other thing we have from the regulations says that agencies have to assure that the interests and affiliations of members are reviewed for conformance with ethics rules. So my question to both of you is, what role does your shop play? Either with respect to what's being referenced here, either in terms of being consulted prior to appointment, in terms of engaging in what appears to be, I'm assuming that the second one is making reference to, conflicts of interest and other types of ethics concerns that any of the advisory committee members might have. So what kind of role does your office play, and kind of when do you step into this process, and who are you communicating with, and what does that look like in each of your organizations?
Well, in our case, like I said, we have a very decentralized system at the agency. So we have deputy ethics officials, for example, that are associated with each of the FACA committees, and they're the ones that review, sign the forms. In our case, in General Counsel Ethics, we will get consulted if there is a question concerning a conflict of interest that they are unable to resolve, or they have certain questions they want to ask us about potential conflicts of interest or things of that nature. But outside of that, that's actually devolved down to the deputy ethics official level. So. Okay,
so that would be like in regional offices? Is that what you're referring to?
It wouldn't be really to a great extent in our regional offices. Mostly our headquarters offices that either deal with FACA committees or the places where we have SGEs, that are at headquarters. There almost certainly are some SGEs in regional offices, and those would be their financial disclosure forms would be looked at by the deputy ethics officials in the regions.
Okay, Karen, what role do you all play?
So as I mentioned, since most of our committee members and panel members are automatically assumed to be SGEs, we really don't play much of a role in that. And it is the program officer or designated federal official who reviews the conflicts of interest forms and determines whether or not there's some issue. For our non-FOKA SGEs, again, it's personnel that lets us know when they're on board, and we would do the collection of the financial disclosure and the review.
Okay, so then there you take a much more direct role in sort of counseling them, much the way you would like a regular employee.
Right.
So again, can you repeat, who is it again with respect to your advisory committees who does that work?
The designated federal official.
Oh, the designated federal official.
DFO, it's called. So
I'm curious, what kind of training have you guys been giving those folks, or how have you equipped them to do that job?
Well, we have a very active committee management office, and they're in charge of that. And our office oftentimes is asked to give a presentation to the advisory committee members, which includes the DFO. And oftentimes our DFO is what we call a conflicts official, who is a local permanent employee in each of our offices who regularly receives training from us.
Right. And they're probably the ones in the best position to have a full understanding of what the committee's doing, what's coming before the committee, and what even the potential for conflict might
Absolutely.
be. That makes sense.
And I want to make 2 points. We, in our case, we have, by EPA order, we have deputy ethics officials, and and they're the ones that are, make the decisions, sign the our financial disclosure forms, and we also provide them with training, as well as when we have certain, for example, FAKA committees that have mixed representative and SGEs. In that case, the general counsel does get involved, and every time a committee charter is renewed or anytime new members come on, then we get involved to make sure that the members are properly designated as either special government employees or as representatives. So it's very important to get involved in that, because you want to make sure that you're not designating people as representatives who actually should be special government employees. That's very, very important.
Absolutely. And we're going to give you an opportunity to talk about that in a lot more detail in a moment. So for non-FAKA SGE designations, again, we were talking about that these would be like individual experts and consultants who are not necessarily working on any kind of an advisory committee. Very often they're appointed pursuant to an agency's own internal personnel rules. And that, in this instance, the agencies also have to designate the status of people who are non-FAKA SGEs, again, to make sure that they really are government employees and deserve the status of SGEs. And Karen, I think I was going to ask again, like what role does the ethics shop play with non-FAKA folks, and whether or not it's distinct from what you do for FAKA folks? Now, and obviously at NSF, it is different. You play a different role. How about you, Dan?
Well, the vast majority of our SGEs are FAKA.
Okay.
Yeah,
okay. Just for informational purposes, and if you guys if either of you have any commentary on this, we ask the question on the annual questionnaire every year whether or not agencies have written policies or procedures for designating SGE status. And as you can see, only 40% of the federal government agencies actually have policies and procedures. Now, that can be, I think, I'm not sure exactly whether or not this question addresses only those people who have SGEs. I'm assuming it does. But I'm curious, do you all have policies and procedures, written policies and procedures?
Yes, we do. And what we did is we took a lot of legal advisories that OG has put together over the years, informal letters, and put it all together in one document, which we then use as our benchmark for helping people decide whether someone should be an SGE or a representative. So we always refer back to that document when we have questions concerning that. And of course, we play the consultative role in general counsel to make sure that happens during committee, when the committee is designating members either as SGEs or as representatives.
Okay, very good. Karen?
So it's our personnel office that has written procedures as to who gets designated as an SGE for non-FAKA purposes.
Okay. So then the next question was, and you all have kind of answered this one too, but maybe I'll punt it back to you again just for clarification. So if you had to when you did have to answer this question, which office at your agency, makes a determination that an individual is an SGE? And Karen, I think you're saying that for non-FAKA, it's the personnel office?
Well, it's the hiring office who informs the personnel office that that's what they want.
Okay. And Dan, you said it's your...
Well, for FAKA, it's actually general counsel, so we probably would fit in the others. So, but it's sort of they sort of work with us in the ethics office. So, so you could kind of say it's us.
Okay. Just curious too, like I know that a lot of agencies are concerned about, and one of the biggest questions that they have is, how do you establish the kind of cooperative relationship that you need with your HR, with your personnel shops, or with any other organization that you have to work with in these circumstances? So I'm kind of curious if either of you have some, best practices or some words of advice for folks about how do you craft those kinds of relationships with those people you have to rely on to do this function that obviously affects your ability to do your piece of the work.
Well, NSF is a very small agency, so we do routinely work with our personnel office, and we know them, and we regularly meet with them when issues come up.
We have, we're sort of a medium to sort of, well, I guess, I don't know how you would call 15,000 people up, at least as a medium agency. And in our case, luckily, there's a most of the folks that are in the HR and personnel are at headquarters. So, we can just go over and talk to them, or we use this device that's sitting about 2 feet in front of me called a telephone. or use that other new marvel called email and say, let us know what's going on.
Okay.
So the only way to build those personal relations is simply to build them.
Right. Very good advice. Okay, so now we're going to sort of turn to this whole question of representatives, which is, SGEs versus representatives. And as we mentioned before, the key thing with representatives is they are not employees. They are not considered government employees. So consequently, they are not subject to the criminal conflict of interest statutes or to the standards of conduct. And you were saying that one of the indicia of being a representative is that they are intended to represent. I mean, that is their whole purpose, is to represent some type of non-governmental group, whether it's an industry, whether it's a consumers or some identified outside group outside of government. And the intention is also then that because they're representing that group, they're coming in with that particular point of view.
You hope so, because that's why you have them there in the first place. The way I always remember it, because, in my simple mind, I've got to remember things in shorthand. The way I look at it is they're wolves in wolves' clothing. There must be a reason you put them on there. And by the way, when you are putting together this chart to figure out, they're representatives, you got to know what group what interest group they're actually representing. Okay, it's have it nice and clear so you know who these representatives are and what group they're representing. Because if you don't know, then nobody else on the committee is going to know, and the public isn't going to know.
Right. So we've listed here some of the authorities that you consult to help inform whether or not they're actually representatives or intended to be representatives. And I know that sometimes in like the organic statute that establishes them, that you'll find an indication that, that the Congress intended that there be certain representatives, and they'll even use the word representatives, but that's not always the case, correct? I mean, the language can sometimes be not entirely clear.
No, sometimes it's not clear at all. Although in EPA's case, most of that legislation is in fact fairly clear, but in other cases it's not. Well, let's say you want a representative from different parts of the country or something like that. So you've got to look at your enabling legislation carefully to see what it tells you about the designation of members. So.
Now, are there other authorities? I mean, we've listed some other authorities here, but in your own experience, have there been other authorities that you've had to consult other than like legislation and establishing organic statutes? Is there any other authority that you have seen where those kind of stipulations would be?
Yeah, if it's a non-statutory committee, you got to look at the charter.
Okay.
And by the way, those charters can change over time, because sometimes the charter is renewed, and sometimes the charter may be renewed in such a way that may change the makeup of the committee. So you have to be aware of, for example, if you had a committee that was all representatives, and now the nature of that committee has changed. And if you're listening to me out there, you know that sometimes that actually can happen. And sometimes you may find that you may need now special government employees to provide expertise in an area to help your committee. If that occurs, don't just appoint them as representatives just because everybody else in the past has been a representative on the committee. Think about appointing them as special government employees, because you're hiring them for their expertise, not who they represent.
Very good. No, and I think that's really wonderful advice, because I mean, I think that's exactly it. If these things aren't set in stone and they are dynamic and they need to be periodically reevaluated, I think it's really good for people to have a heads up about that this does not mean that once a representative, always a representative. So I said I was going to give you a little document that sort of pulls together some of the more seminal OGE advice memoranda that deal with SGEs. And this is for your convenience. I'm not going to go down through the list here, but just so that you're aware that they're there, and you can find these on the Office of Government Ethics website. If you look under our legal advisories tab, You should be able to quite readily find these by year, actually. And here's a little list of advisory committee best practices. And one of them, among many, is, to be involved early on in the appointment process to make sure that, that you're catching people with conflicts or helping people who are making those decisions do their job to the best of their ability, so that you're keeping your committees, as conflict-free as you possibly can, because that's one of the sort of like the interesting conundrums with SGEs, is that the very reason you want them is for their expertise, and typically expertise comes with its own set of, relations and interests that may very well be in direct conflict with what you actually want them to accomplish. So without further ado, I'm going to turn the microphone and whatever over to Dan, and the slide deck over to Dan. And Dan's going to talk to us a little bit about the ethics rules that apply and how to manage your SGE's ethics issues.
I'm keeping an eye on our time, so it's about
We've got an hour. We've got an hour.
We got an hour. Oh, excellent. Okay, great. So what I'm going to talk about here is the sort of core ethics rules that apply to SGEs. I'm not going to give you a detailed review of all the ethics rules and regulations, because you know what? This is not going to be a memorization exercise. Instead, what I want to do here is just to point out some of the key issues for you. I want to talk about some of the things that you have to watch out for. And as I said before, EPA is very decentralized. We have deputy ethics officials in each and every one of our offices. All of our faculty committees has a deputy ethics official, and their power is sort of delegated by internal EPA order. I don't know how your offices operate. They might be different. In EPA's case, we have exactly, 2 full-time and 2 part-time ethics official and general counsel ethics. And we have 15,000 employees, in both headquarters here in DC. Got 10 regional offices, lots of different other labs and facilities, and we have several hundred SGEs. So if you think we're going to be able to look it over with the, 3 basic FDEs we've got in general counsel ethics, that, we need to depend on our deputy ethics official, and you may be in the same situation as well. So what I'm going to do now is show you some of the basic laws and regulations. One I did not put in here, so I'm going to start with one that's a little not mentioned, but it's a little less familiar, and that's 18 U.S.C. 209. That's supplementation of salary. That actually does not apply to SGEs. However, you should know that under 5 CFR 2635.807 says that an SGE cannot get non-government compensation for teaching, speaking, or writing if it's undertaken as part of official duties or any matter to which they're assigned or been assigned the previous 1-year period. But it only applies during their current appointment, and if they serve less than 60 days, it's only specific party matters that are covered. That's not to give you a memorization exercise. It's just to show you that the regulations covering special government employees are not that straightforward. You've got to look at them, and you have to look at several aspects of what your committee is doing, so you'll know how to apply the right ethics rules and regs to your SGEs. Let me just talk a little bit about 203 and 205. Obviously another criminal statute, and that talks about representation back to the federal government. But it turns out if you're an SGE and it's less than 60 days, it only applies for specific party matters, grants, contracts, enforcement actions, that sort of thing, that the SGE participated in. But if they serve over 60 days during the immediately preceding 365-day period, they can't represent back on any matter to the particular agency where they're working. But the rest of the government's okay. But, they say on those knife commercials, but wait, there's more. Let's talk about 18 U.S.C. 208, shall we? That's the criminal statute concerning conflict of interest. It's the one you're probably, most familiar with. And I think that's fascinating to look at that in the context of congressional intent concerning special government employees. And I'll tell you why. So, as many of you know, if you're working on a FAKA committee, if an SGE is working on a FAKA committee, they're actually eligible for a waiver under B3. And the criterion for that waiver is that the interest of the government has to outweigh the potential for conflict. But if they're not working on a FAKA committee, they can't get the B3 waiver. They only can get the B1 waiver. And in that case, it's the same B1 waiver that all of us who are regular government employees are held to. It's a standard that the conflict can't be so substantial as to affect the integrity of employee activities. Do y'all see the difference here? There's clearly two types of SGEs, and that was clearly Congress's intent when it wrote this law, because there are really two types of SGEs: those that work on FAKA committees and provide advice, right? That's where you have them there. They're providing advice to your agency. And then there's the other SGEs, the non-FAKA SGEs. What are they there for? Well, they're sort of the worker bees. They work alongside of you, every day, and you may or may not know that they're SGEs, right? But they're there to do perhaps more than just give you advice. There's another exception to go even deeper into the weeds here under 264203G, that if you're an SGE and you're working on a FAKA committee, you're not going to have a conflict of interest, and there's a whole bunch of extra language in there, which I'm not going to get into. You're not going to have a conflict of interest by virtue of where you work, but only on matters of general applicability. Those are particular matters that affect a group of people as a class. In EPA's case, it could be utilities, oil refiners, that sort of thing. Now you think, wow, that's a huge exception. And it sort of is, but while they will not have a conflict of interest because of where they work, that doesn't extend to their financial interests. So that's great. You can hire somebody who works for, ABC Chemical Company, and they can work on a matter of general applicability, which could affect ABC Chemical Company, as a class, and that's not a problem unless they happen to have, it's over $25,000 in stock in ABC Chemical Company, in which case now they got a conflict again. So, okay, everybody confused yet? Okay, if you're not, you ought to be. I know I was, and there's even more exceptions here, which Karen's going to get to in a second, for things like fundraising and emoluments and accepting gifts from foreign governments. So if you think we're done with this, we're not.
Dan, I wanted to jump in here just for 1 second. A couple of things came to mind for me. You were talking about how kind of the mind boggles with the exceptions under 203 and 205 for SGEs, because it carves out an exception for SGEs who are serving on advisory committees.
208.
But then it goes on to say, but then if you don't serve more than 60 days, and so we've got day counting, and then we've got day counting on top of day counting in order to be able to determine what of these laws apply. So I'm curious as to do you put that all back on the SGE to keep on top of their day counting? And even if you do that, what do you all do to counsel people so that they understand? This is complex enough for us to get our heads around. How do you help SGEs even know this or keep track of it for them?
What a great question. And the answer to that question, at least in our case, is we make sure that they actually take their ethics training, which they're required to do. And I must say that OGE has excellent and brilliantly written, I must say, online ethics training concerning
little
SGEs.
Self-promotion going on here, Dan.
And I'm not saying that just because I wrote it a few years ago, although I think I'd probably need to revise it, but that's neither here nor there. But yeah, if you don't tell them, they're not going to know. That's number one. Number two is you got to make sure that the deputy ethics official, in our case, knows that that's a situation. And then they can talk to the personnel person, in their shop and keep track of it. Now, we're lucky that almost none of our SGs serve over 60 days. We love them, but we get rid of them before they hit that 60-day mark. But somebody's got to be minding the shop, and you got to make sure who that is.
Karen, do you have mechanisms for helping people keep track? Or
Well, our FOKA SGEs all work 60 days or less.
Okay.
So that's the bulk of our SGEs, about 16,000 a year.
Wow.
And the rest of our non-FOKA SGEs, it's the personnel office that keeps track of their days.
Okay. Very good. I think that was the only question I had for you. So you go right ahead.
So I'm not going to go into all the standards of conduct because we'll be here all day. So let me just talk a little bit about financial disclosure. Now, you all know you're going to have to collect these reports, right? And someone's going to have to review them, just like somebody reviews the financial disclosure reports of all the regular government employees, right? And I mean, it just has to get done. And both NSF and ourselves, we use our own form approved by the Office of Government Ethics because we needed more, frankly, we need more information than we were getting out of the 450. And we need information on people's contracts and their grants and whether there was any reason they couldn't serve on a committee, and and we just need that information, right? And the fact of the matter is you're not going to get that on an OG 450. So, and then you have to be aware of other things. If you pay an SGE over $59.02 an hour and they work more than 60 days in a 365-day period, guess what? Those lucky people have to fill out the OG 278E form. They become public filers. And not only that, and believe me, when you tell them that now their financial disclosure forms are going to be made public just by the filling out of a certain form, see what happens. And not only that, but now they're covered by the Stock Act. That means now they have to go through everything having concerning, reporting their stock transactions periodically on the 278T form. They now have to give you notification of negotiation for employment and all that other good stuff. So you got to keep track of their days, and you got to keep track of what you're paying them as well. So just because you have somebody there keeping track of the days, make sure you know how much you're getting paid too, because that could be a problem. Okay.
So, and people have to annualize that, right? Whatever they're being paid per hour, you annualize that to decide if they meet the reporting threshold.
That is a good question. We pay them by the hour, so I think that's right. It does go by the annual. So the question is, and what I think I tell folks is that you got to give them training, and the question is, are you keeping track of the training? Are you making sure they take training on an annual basis, right? And who's keeping track of the training? Are you keeping track of the training? Do you have a system for keeping track of the training? Are you relying on somebody else to keep track of the training? These are questions you're going to have to ask yourself. And I guess the takeaway I want you to take out of this one screen here is, the SGEs are in fact covered by, more or less the same ethics laws and regulations that we are, but there are a lot of exceptions there that's going to require you, as an ethics official, if you're listening to me, it's going to require you to monitor what these SGEs are doing. You can't just go set them off and let them set sail, right? You got to know what the heck they're doing. So let me talk a little bit about the ethics issues that you'll see on panels, or at least that we see on panels. So let's look at the panel formation process. So the question is who's collecting this information for you? Are you doing it? Are you relying on your DFO to do it? Maybe you're working with your committee management officer or your management to collect that information. But someone's got to collect that information, and you got to make sure, if you're not directly responsible for yourself, who's collecting the information, right? You've got to ask yourself the question, what are the matters that are going to be considered by the committee? Are they matters, or are they particular matters? Are they particular matters of general applicability, or are they going to be particular matters that affect specific parties? because each and every one of those determinations is going to tell you how the ethics laws and regs are going to apply, right? And then once you determine what those ethics issues are, you got to figure out what kind of remedies are you going to apply. Are you going to make them divest? You know, remember, they're SGEs, so they can't get certificates of divestiture. Are you going to sort of make them recuse from part of the discussion? Are you going to tell them, sorry, you can't serve on this committee? I don't know. Those are things that you have to figure out before you put them on the darn committee, right? Then during the operation and termination, you've got other questions. You've got to vet ethics issues before each new matter and for post-employment. You know what? If you have a standing committee, I bet you they're going to talk about more than one matter, right? They're going to go listen. They're going to go do deliberations on one matter. The matter could change. The committee could reform. They could start talking about another matter or another particular matter. And all of a sudden, the SGE, which you thought was fine for one particular matter, is all of a sudden has a conflict on another particular matter. And unless you know, and have either reviewed it yourself or had somebody in your shop do it, review it, then you don't know if somebody's going to end up with a conflict of interest, and you don't want that.
I just want to jump in here real quick, Dan, and just to sort of put my 2 cents in, which is to say that I know that a lot of questions that when I was serving as a desk officer, a lot of the questions that I got over the years from small boards and commissions and from folks who were dealing with advisory committees on a regular basis was, I think, particular matters of general applicability are sometimes difficult matters to identify. And I would really encourage you, if you're uncomfortable with sort of making those determinations or you're not real certain about it, to try to reach out and get some assistance with those determinations, because too often we had too many folks who thought that unless they were specific party matters or things that you could identify as specific party matters, that 208 wasn't a problem, and that you really didn't have, that your committees and your advisory committees didn't have conflicts because you didn't deal with specific party matters. And that's just simply not the case. So I would really encourage you to make sure if you're advising advisory committees, or if your CMOs are the ones who are doing it, whoever's doing your conflicts analysis for your advisory committees, that they really have a really good, strong sensibility about what a matter of general applicability looks like.
And by the way, OG has some excellent guidance on the website about concerning particular matters and what they are, and how to make that determination with matters of general applicability and specific party matters. So I encourage everybody to go print it out and keep it in a file somewhere near you. And lastly, I want to also talk about communication during charter and membership renewal, because you know what? Your charter can change, your members can change. You could have SGEs on there that are may have a problem with the new panel. You could have people who are representatives are now they're now SGEs, or maybe you need SGEs on your new committee. You don't know unless you check. So, how do you avoid some problems? Okay, well, like I said, my whole presentation here is basically the view from the trenches, so to speak. I have very rarely seen a disclosure form that didn't need a follow-up. That there's going to be something on there that either looks funky or needs more explanation, or you just need to know what's going on. So, do your follow-up. Don't forget about subcommittees. You could have a charter committee, but now you got all these subcommittees that have SGEs on it, and you're figuring, oh, well, it's just a subcommittee. It's okay. Everything's going to go ahead and get reviewed by the committee. Wrong. You need to make sure that if you have subcommittees and they're SGEs, you're going to have to collect the financial disclosure forms. You're going to have to see if there's a problem there. It's not just your charter committee. It's anybody that's got their hands, on this information. Work with your DFO on the committee charge, okay? Because once you know what that charge is, you're going to know, or at least have a better idea, what are the matters that are going to come up? What kind of particular matters? Is it going to be specific party matters? You got to know when that matter is going to, matter, so to speak. I sort of live by the saying that if it's not documented, it didn't happen, simply because if you don't write it down, you're going to get yourself into this he said, she said sort of situation. And someone's going to say, well, 6 months ago, you told me it was okay to do X. And you're going to be like, I didn't say that. And oh, yes, you did. And no, always follow up with a note saying, on such a day, we discussed whatever. Remember your remedies, right? Divestiture, recusal. Maybe they don't serve on the committee. Just remember what your remedies are. And lastly, what I wanted to say here was expect the unexpected. What are you going to do if your SGE comes to you, it's just before your public FOKA meeting, and tells you that she's just signed a contract to do some research with the very specific party that's directly and predictably affected by the specific party matter that's the subject of your meeting? What are you going to do? You're going to tell her not to attend, tell her she can attend part of it. You're going to ask her if she's already participated, in which case you already have a conflict problem. You're going to try to get a waiver if there's no participation. I don't know. You know, God forbid this should happen to you. But if it does, at least have in the back of your mind what you're going to do in case the unexpected happens. Let me just talk a little bit about the major differences again between SGs that are, not on FOKA panels and those that are on FOKA panels. And, this just speaks to what I said earlier about the fact that there's really two flavors of SGEs, those on FOKA committees and those not on FOKA committees. Just to remind you, if they're not on a FOKA panel, they're not going to get the exception for general applicability matters by reason of their employment. Karen will talk a little about the emoluments clause, and they don't get the exception there. They don't get the B3 waivers because they're not working on FOKA committees, so they're held to a higher standard if you're trying to get them a waiver for a conflict of interest. And the bottom line is, they're usually not there just to give advice to the government. They're the worker bees. They're going to show up every day. You're going to see them, right? And the question you have to ask yourself is, are you dependent on others to collect this information for you? Who's minding your ethics store, right? It's possible you're going to be relying on other ethics officials to do their job so you can do your job. Do you have a decentralized system? How confident can you be? How much can you trust the ethics officials that you're relying on? Are you giving them any specialized training? Are you communicating with them? Those are the sort of the questions that you just need to ask yourself. So just a little reminder about what to do before, during, or after. Before, believe me, it's better to vet your SGEs before they show up because you don't want to actually hire them and find out they have a conflict of interest and can't participate, because that doesn't help out anyone. Beware of resurrected employees, those that were RGEs, and suddenly you've now shown up as SGEs in a new life, and as SGEs and now have outside employment and outside financial interests, and you're going like, what? And the answer is, yeah, that can actually happen. And just with all due respect to the first screen that you showed, I say SGEs are special with a big S, but they're not special with a small s. You don't care where they came from. You don't care who they are. All you know is they're special government employees now. They get some variation from the ethics laws and regs by virtue of the fact they're SGEs, but that's it. And during the panel, no disclosure, no excuse. Okay, they have to tell you what they're doing, and they have to give you a full accounting for what's going on. If they're not telling you, or you're worried that they're not getting the full story, ask. Watch the days, because remember we talked about earlier, the number of days they work makes a difference, and there's a whole nice writing from OG about day counting and what counts as a day. If you work for just 1 hour during a day, that's considered one full day of work for the purpose of day counting. Now, it can't be like ministerial duties, like, hey, can you come to this meeting on Thursday? Okay, that's not work. But if they're even doing any homework for 1 hour, bam, that counts as an entire day. be the reference, because someone's going to have to talk to these people and help them out if they have questions. And, you know, you're going to have to be the reference for them. And the more you ask, the more you know. You have to find out what's going on. Be inquisitive, be nosy. That's okay. They understand. And after, you have to remember, you know what? The SGEs still aren't special. They may be special with an S, but they're not big S, capital S, but not special with a small s. They're just another ex-government employee, just like everybody else. You got to watch their days, and you got to watch the money, because if they make over $76.71 an hour for this calendar year and work over 60 days during the previous 365-day period, guess what? Then they got a cooling off period, and they can't represent back to their agency for a 1-year period. So you never know. That could be a problem depending on what you're paying them and how long they work. And the last piece I put in there is beware, you might see them again as they transition. You know, God knows what will happen in transition. You might see people who are employees that might show up again sometime in the future as special government employees. Don't really know yet, but could happen. And last but not least, I wanted to give some sort of parting words of wisdom. This is sort of based on the fact that I've been at EPA for 26 years, and this will probably be the last time I'll ever get a chance to do this. So let me give you some parting words of wisdom. You know, I sort of quote Yogi Berra here. It's like deja vu all over again, okay? And the reason I say that is, you know what? You're going to see the same problems over and over and over again with different SGEs, sometimes with the same SGE. Consider creating some sort of system that's going to organize your advice so you can make sure you give consistent advice over time. The oath of office is more than just pretty words, because remember, you had to take the oath of office, right? You know, well, guess what? So do SGEs. And it should be as real for them as it is for the rest of us. And you know why? Because in the final analysis, public service is a public trust, right? Where you sit matters, not where you stand. You know, you're the ethics official. It doesn't matter what you think about what a committee is doing. Doesn't matter what you think about the person. You know, you are the ethics official. You're the one that people are going to be relying on to give the right information, to give the definitive answer, and to help make sure that the integrity of government operations are upheld. You got to know who you are. You got to know what your role is in the organization. You got to know who you're going to rely on to perform these ethics duties. And you got to ask yourself the question, how confident are you in the ability of these people to carry out their duties to help you? How much can you trust them? And last but not least, I wanted to say, you are never alone. Like I said, after my many years of government experience, I can guarantee you I'd be happy to plug OG. They are here to help. They've got great information and great people. You got a problem, they're a resource, talk to them. You can rely on them. With that, I'll be quiet.
Well, thank you, Dan, very much. Karen, it's your turn now, my dear. Patrick, we have a question?
Yes, actually, we do have a question that's probably timely here. We have another one that we can leave for the end, but this goes back to the day counting exercise, and it's interesting to me that the counting of the day seems to be the hardest part here.
Right.
And the question is, there are some authorities, statutory authorities, including 5 USC 3109 and 5 CFR 304, that allow agencies to appoint experts and consultants for terms in excess of 130 days. So have you dealt with this, and how do you characterize them under the SGE rules if they're going to be experts and consultants for more than 130 days? Or maybe you don't have any.
I think that the definition for SGE is 130 days or less. So I think by definition, anybody who's hired for any purposes who's going to exceed 130 days is by statutory definition, not an SGE. I think that one is pretty straightforward.
Great, thank you.
Okay. Patrick, can you put us on the...
So I know we want to leave time for questions, so I'll be brief. What are the other ethics rules that we have to be aware of? I'm going to briefly expand a little bit on some of the topics you heard Dan talk about. At NSF, as I mentioned, we have an alternative form for our FOKA SGEs. It basically is a certification. It lists affiliations that may raise potential issues, such as the ones you're seeing on the slides here. And the SGE signs it and certifies that they don't have any of these affiliations. However, even though they sign this form before the meeting, we make sure they know they have a continuing obligation during the entire course of the meeting to disclose anything that might come up. For example, when they're looking at a proposal, maybe deep inside that proposal is a student of theirs, and that's not apparent on the cover sheet or any other place. So they would be obligated to tell us about it. For non-FOKA SGEs, they file the usual 278E or 450. We have the ability to exclude filers from the 450 for our non-FOKA SGEs. You can do that if the possibility of a conflict is remote. At NSF, we have persons known as senior science advisors. They don't have any grant money responsibility. They are there to give us advice on the direction of research, so they could be excluded under this. Also, if they have a low level of responsibility, such as they're inputting data or they're using existing data to prepare reports, that might be circumstances in which they could be excluded from filing. NSF makes liberal use of OGEs, granting the ability to use written training instead of in-person. You heard of our numbers, and so we do use written training for our FOKA SGEs as well as our non-FOKA SGEs. We often have people in remote locations, as I mentioned, Antarctica, and so we use the written training for them. And Dan mentioned—
You mean you don't get yourself a trip to Antarctica so you can do an in-person briefing?
that might be in the card. Dan mentioned several of the topics that are covered, and let me go into the emoluments clause. So that basically says if you work for the U.S. government, you cannot also be employed by a foreign government. And my understanding is that this clause was enacted in the Constitution because when Ben Franklin was ambassador to Paris, he came back from a trip to France with a jewel-encrusted snuff box. And some people got upset about that and worried about potential undue influence from foreign governments. Now, this clause is going to implicate a FOKA SGE, for example, who may hold a professorship at MIT, but also has a visiting appointment at a university in China. It also may impact reviewers from foreign countries who have appointments with foreign universities that are considered part of the foreign government. So there is a series of OLC opinions, most notably one in March 9th, 2005, concerning the President's Council on Bioethics, and also a subsequent OLC opinion on June 15th, 2007, concerning the FBI, that basically states the emoluments clause does not apply if they're on a committee and it's purely advisory. And so we have relief in that respect.
Can you just briefly repeat just the references to those, just so that folks on the phone and on the Hangout, if they want those references, can you just briefly repeat those?
Certainly. It's OLC opinion dated March 9th, 2005, and June 15th, 2007.
Great.
A provision enacted by this administration is for FOKA SGEs serving on committees, and that is they cannot be federally registered lobbyists. And there are databases you can check for that, but again, given NSF's number, we rely on certification. All our FOKA SGEs has to register with us, and as part of that registration, they sign a certification that you see.
So this is that's the certification statement?
Right. Other lobbying considerations depend on what hat the SGE is wearing. If they're appearing before Congress as a private individual, as the dean of a school, as the president of a scientific society, they can lobby all they want, provided they're not on duty and they're not using United States government resources for those purposes. If an SGE is going to represent NSF, NSF has to authorize them to do that. We want to speak with one voice. And so they would work closely with our Office of Legislation and Public Affairs before giving any testimony before Congress. There's also something called grassroots lobbying, and that's when you encourage others to contact Congress. We had a chair of an advisory committee who wanted to send a letter to every dean at every university, encouraging them to call their Congress members to increase the NSF budget.
Oh, wow.
And we had to put the kibosh on that.
Very nice intentions, but.
So does the Hatch Act apply to SGEs? It does. Take a look at 5 CFR 734.601, which says the political activity for irregular, occasional basis employees is covered, and that's an SGE. However, the application is narrow, and that is it only applies when they are on duty. So for example, if one of our proposal review panels meets from 8 to 3, an SGE on that panel could go to a political fundraiser at 5 o'clock. And in fact, they could solicit fund for whatever candidate the fundraiser was being held for.
Interesting.
And by contrast, we've got our non-FOKA SGEs who we treat as less restricted employees. So the not in the government building, not while on duty, not using government resources applies to them, but also the restrictions that apply 24/7, we apply to them as well, such as no fundraising and the limitations on running for public office. I wanted to highlight a couple of recent developments. Keep your eye out for a GAO report on SGE engagement. GAO came to NSF, HHS, DOJ, State Department, and NRC, and their focus was non-FOKA SGEs. And the impetus for this was Senator Grassley looking at the former Secretary of State Clinton's aide, Uma Abedi, who is married to a congressman who likes to take selfies. She was a regular employee at the State Department. She became an SGE, and as such, she had other employment, which is very, very typical. However, he has this like a dog with a bone and is pursuing it. And so all these other agencies were asked questions such as, how are SGEs designated? How are they tracked? Who's responsible for training? How is financial disclosure monitored? And they also asked us how many regular employees turn into SGEs. So we expect a report on that shortly. And I want to wrap up by calling your attention to proposed legislation, FOKA amendments, HR 2347. It passed the House and is now in a Senate committee. It has some significant implications. For example, it states that the DAEO should review FOKA committee designations when the charter is written and anytime the charter is renewed. And it makes certain information publicly available. For example, the reason why a committee member was selected, recusals, waivers, description of the conflict, the reasons for granting it, and the minutes. And so if you are not aware of this, I urge you to contact your committee management office and get the full extent of this.
Okay. Well, why don't we open it up for questions? Dennis, I would like to open up the phone now for questions that anybody has on the phone. And if we have anything on the Hangout, we're happy to entertain any questions that you have.
Thank you. At this time, if you'd like to ask a question, please press *1 on the touch of your phone. You'll be asked to record your name prior to asking your question. Again, that's *1 on the touch of your phone. One moment, please.
And if folks on the Hangout have a question, you can ask your question by typing in the lower right-hand corner of your screen.
Well, while we're waiting, well, first of all, I want to thank you both for coming and re-presenting what you presented at the OGE Summit. One question that I had for both of you was, to what extent do your folks do any sort of pre-appointment vetting? Like, do you use the 450 at all, or are you aware whether or not any of your committees use the 450 at all to do any sort of pre-appointment vetting before actually appointing people to the committees?
Well, in both of our cases, we have our own financial disclosure form for faculty committees. But yeah, in our case, they collect the financial disclosure form and vet it even before they're appointed.
Right.
So why bother bringing somebody on if they're going to have some sort of fatal conflict? I mean, there's just no point. You'd be wasting their time and ours.
Right. Do we have any questions on the phone?
Ma'am, at this time, I show no questions in the queue.
Okay. Patrick, are we?
And we don't have any further questions on the Hangout.
Okay, well, I think that that we've obviously answered everybody's questions and given them all the information that they wanted to know. Again, thank you, Karen, and thank you, Dan, for being here. I appreciate very much you sharing your expertise and your policies and procedures with the community. And I want to thank you all for having joined us this afternoon. And please tune in next week for the Advanced Practitioner Series. We'll be dealing with FOIA, the Ethics in Government Act, and the Privacy Act. And until next week, thanks and have a great afternoon.